All right, welcome everybody to our first January 2024 ISC2 Seattle chapter meeting. For folks in the room and folks online, thank you very much for attending. Hopefully that video is making it through online too. I see myself, so that's a good sign. Well, maybe that's not a good sign. A little bit of agenda that I wanted to cover today. And let's go to the agenda slide. There is one slide that was added that last minute. However, we'll talk about board members, conferences, a little bit of interaction as to what your thoughts are as to where we can go in 2024. We had actually the board had a great discussion during November about speakers and what we expect to do in 2024. So we'll try to share that information with you online on our website. So please keep checking in on that for all the information. A little bit about our board members. Myself, I'm still the standing president. Jean, who is very, at least based on the message I received from her, I don't know if she's online, so I want to say this with caution, but she was not feeling very great. She's actually been dealing with something that's just like not letting her go as far as the illness goes. Lori, unfortunately, our treasurer right now is just recovering. She also had a little thing occur that required her that she won't be able to be here. Jake's not here. Oh no, I'm sorry, Jake's here. Agnes isn't able to attend. Stephen is our webmaster and located on the other side of the Cascade Mountains. So he's online and actually doing our online moderation. Thank you, Stephen. Micah, our AV person, is in the room, running around trying to get everything running and set up. So you know, bear the mess here. I don't know where Paul is, and unfortunately, I don't know where Melody is today. So a couple of absent board members. Unless you're online. If you're online, speak up. They didn't speak up. Sponsors, Menlo Security, and we have Microsoft as a donor. We're always looking for additional sponsorships, and we have a very easy entry for our organization. Interestingly enough, one of the discussions that we've been having is how much influence we want from sponsors. And the reality is we really want to minimize that because we're an association for education, and our intent is to continue trying to preserve that. But we do have some expenses. And one of the expenses that we will probably be transferring to all our members in the near future is a small membership fee or attendance fee for our meetings, mainly for us to be able to operate. Alternatively, the other thing that we've been considering is we won't be serving food anymore, just again, to try to cut back on costs. So the glass donation jar is also the option. Donate as much as you can tolerate. We're always interested. And if you are a Microsoft employee, ISC2 Seattle chapter, actually, if you're an Amazon, Microsoft, Google, or any company does a match, we take donations. We are actually a 503c and can receive charitable from all organizations as an educational institution. If you didn't sign in physically for your CPEs, make sure you write down your name, your information. It's a piece of paper, relatively simple to sign in. Online, when you join the Zoom call, if you provided your ISC2 number, your time will be recorded and it will be reflected on the website within a reasonable period of time, which could be up to about a month, unfortunately, at this point. So we're on social media, LinkedIn, YouTube, and website. If you haven't actually, if you're here and you're online, that means you've hit our website. So I won't hit on that any further. A couple of conferences that we wanted to note. Eastside in April 27th is coming up. I think it may already be sold out. The cybersecurity conference, FutureCon, February 29th. I don't know. I personally haven't heard about this one yet. NLIT Summit, the laboratory, which is April 8th through 11th. And then we'll obviously be participating in Secure World. If you know of events in the Seattle area that we should be promoting, please let us know. We'll happily let folks know about these events coming up. So we want to hear from you, future topics, speaker sponsorship, and contacts with universities. One of the things that our chapter has been pondering for probably half a year now is our involvement with local schools and secondary educational institutions. ISC2 is here to promote that process of moving into the new program, the CC. If you haven't, actually, here's kind of a question mainly for the room is, how many are seeking your certification process or have not received it so far? Everybody's certified? You're seeking, interested, possibly? So one of the things that ISC2 has introduced is the CC, the Certified Cybersecurity Program. And it's actually very simple entry. One of the considerations that we're trying to do probably this year is to host weekend sessions to help folks pass the test. It's not a very difficult test. It's a relatively simpler. It is kind of like your foot in the door to get exposed to ISC2. You get certified as just an entry-level practitioner. And certainly one of the things that, for all of you, it's the impact with educational institutes and students. We want them to become aware of this, and we want them to also participate. So if you like it, spread the word, and we'd always be interested in how we can actually expand that engagement. Now, interestingly enough, one of the other things that's kind of a last-minute addition is we are up for election. We are required by our bylaws to meet this requirement, and we would love to get additional candidates. So there's 1, 2, 3, 4, 5, 6, 7. Yeah, because he said that if anybody runs for secretary, that it was a rigged system. So we already know that. Oh, I see. Okay. More importantly, though, today, right now, I am going to try to wrangle one of you who came here tonight. We need an elections director. What does that mean? It's really relatively simple. Ballots are going to be put together. And when I mean ballots, it's literally just an email. For the room, it'll be paper ballots. It'll be a matter of tallying, counting, and declaring winners. The requirement for our chapter is this has to occur because we need to meet our obligations. Your help, I mean, as I said, this is one of the few things where I really need somebody, and especially I've seen some of your faces before, just say, I'll do it. And it won't be that much, it won't be painful, I promise. Additionally, if you feel like you want to participate on the board, notice that everybody's an incumbent. We need some new faces, and it's a great opportunity. I mean, I have a feeling that, again, we could use that fresh energy inside this board, and we'd welcome any position, including secretary. So additional roles that are not on the ballot and will not be is director of membership, director of AV, director, duplicated membership, education, and sponsorship. That was a typo. That was supposed to be our education, because those director positions came in very late. They were actually, they are not up for a re-election right now. Any questions? Anybody want to share your opinion, or you're throwing your hand up and saying, I want to participate? No, great. All right, well, if you're, fantastic. Absolutely, you're already signed up. You see, just like that. We'll fill you in on the detail. It really is going to be very simple. I mean, this is, as you see, all incumbent. So unless there's other names that show up, I welcome it. I really hope so. So to that end, anything else that I need to cover for this? No, thanks. All right, testing your knowledge. Again, we're an educational institute. We want to try to trigger some thought and thinking. Stephen, you're going to do the online, and I'm going to do the in-person. And I do have the chat window up, so you can kind of throw what people are picking, and then I'll share that with the room and do kind of like cross-pollination. All right, so test your knowledge. I won't read the question, but I'll give everybody just a second to read through this and pick your 1, 2, 3, or 4, and then I'll do hands in the room, and Paul and Stephen can do hands online or something online, something clever. So number 1, who's going for number 1? Okay, we've got a couple of hands there. Number 2, number 3, and number 4. No? I saw a lot of number one, so good news is you're right. So payload. Anybody use NetFlow regularly, irregularly? It's actually a really effective way to understand data transactions on your network. I mean, it is not something that you would do unless you're doing network analysis. So, but it's important to know, and it is actually one of the questions that comes up, ironically, for your ISC2 program. Next one is the question of elapsed time between incidents. All right, number one, most hands there. Number two, number three, and number four. Very good. Yeah, it has absolutely nothing to do with it. How about number two? Nobody said number two, but anybody know what number two is? Recovery. Mm-hmm. Yeah, it is for this particular one, repair or recovery. Interestingly enough, my memory tells me it was that it should be recovery, but detection. So it's time to detect. Next question. Ooh, it's a long one. Lots of reading here. Absolutely. These are live, not live. I mean, they're prior questions. So a little bit of a double negative in this one too, which isn't helpful, but I'll tell you, it's, what was I filling out actually today or yesterday? Oh yeah, right. So because we're a not-for-profit, I had to actually apply for a not-for-profit status for our charitable program. And I love it when they ask you you will not do this, and then it's a positive question, right? It's like you will not, you indicate the fact that you will not do this, and then the actual statement was, give money to any government or political factions. So it's like, you're like, well, not do it, and I will do it. So it's a negative, positive, positive, negative. Do I answer yes or no? Never really know. So this is definitely one of those ones where we have the correct answer. Number one. Number two. Oh, I saw a couple of hands. Ooh. Number one. Number three. Oh, name changed. Okay, Tom is like a different person. Number four. Yeah. He's trying to avoid being indicted, right? Yeah, number one. Interestingly enough, I mean, interview versus interrogation, I think, is actually a very interesting concept. But I don't know about you. I've had to face these difficult questions where, you have to deal with either breach or some kind of an incident, and sometimes does feel a little bit more like an interrogation than an interview, especially when attorneys are involved. Never. All right, there we go. Jake, you're up. And I'm not going to introduce you because everybody knows you already.
I hope so.
So,
yeah, that's right.
Oh, and if there's any questions in the room, I have a mic. Jake loves being interrupted. So just let me know and I'll come around with the mic. Online, if you have any questions, I'll try to get online so I can pick up questions. I know that may be a problem. Yeah, hold on.
So it was on the desktop, right? Okay. So I have been this is on, right? I think it is. And make sure it's up. So it's been an exciting couple of years in privacy and security. And I initially did this presentation toward the beginning of 2023, and I have to say I'm amazed at just how much has changed. I think 2023. I don't know what we want to call it the year of, but it was definitely the year of state privacy law enactments and regulatory action. As you'll see, spoiler alert, the FTC in particular has gone gangbusters with its activities and its regulatory enforcement actions. So as we kind of get going, I would ask, think about your role in your organization and how much responsibility you have or don't have for privacy and compliance with government regulations. Some people in the room have all the responsibility, for example. Some people may not even touch it at all. And I think what you need to take away from this is really just know that these are out there, and they're going to impact every single person who is in a security role, whether you're considered a privacy professional or not. And you're about to see why. So the trends
Can someone show the slides?
are at this point pretty cookie cutter. As you'll see in some of the ensuing charts, a lot of the laws look very, very similar. That's because in every state you have a give and take between the privacy advocates and the not sharing. Oh, I got it. Okay, sorry. Now it is, right? I see thumbs up. Okay, so continuing. The privacy advocates and industry lobbyists are really always the ones who are driving the way that privacy laws are being developed. And the main points of contention remain scope of applicability. You'll see two, well, thanks to Texas, there's two. There used to only be one. It was basically revenue versus citizen numbers. Texas had to go its own way, consistent with its Lone Star State motto. They use a definition of, quote, small business. And then enforcement, the question is really, is there going to be a private right of action, which you should read as, will there be class action lawsuits or not? And for the most part, the answer is no. Almost all of these laws are attorney general enforcement only, which is good and bad. If you're a consumer, it means you can't directly vindicate your rights. You can complain to an elected official, and their office can or cannot take an enforcement action. Having been an assistant attorney general, these offices don't have a ton of extra bodies to investigate and bring enforcement actions. So I think in a very real sense, the privacy advocates almost always want a private right of action, and obviously industry does not. And then the last kind of major point is exemption and preemption. HIPAA is the greatest example. HIPAA will preempt aspects of state laws that are inconsistent with it. And does a state want to do what's called an entity level exemption, where they just say, you're a covered entity under HIPAA, you're completely exempt from the state privacy law? Or do you want to do a data level exemption, where you say, okay, you're a hospital, which makes you a covered entity, but we don't care because not all the data is PHI, and all your information that you have that is not medical data should be covered by the state privacy laws. So there's and you'll see that by far the exemptions are pretty broad. They've kind of won out. So let's see. You don't actually have to be able to read this, but this is the privacy laws from 2023. So all of these laws either existed, actually all of them went live in 2023. California had already had a law, but this was a new modification of it. The California Privacy Rights Act took effect January 1st. The rest of them, you can see July 1st, were Connecticut and Colorado, and then Virginia was also January 1st, and then Utah was just last month. So this is, what this means is that it's all still relatively new, and we don't really have a great deal of data or evidence on what enforcement's going to look like in the long term. You know, if you do squint real hard and try to read this chart, you'll see that the rights of the data subject are pretty similar across the board, as are the obligations. There are some differences here and there, but many of them, many of these statutes are, I don't want to say identical, but they've all been based off each other. This is what we have coming up, 2024 to 2026. We have Iowa and Indiana, and I'm not sure what happened to the header line up there, but there should be Montana and Tennessee and Texas as well. That's mysterious. Oh, it does? That's very strange. Oh. No, there's not. And there's also Delaware, and I believe that's it. So what's the takeaway here? Not much other than these, as the title of the presentation says, these are proliferating pretty rapidly. We went from 5 laws that we knew were going to take effect at the beginning of January 2023 to when 7 more states passed laws in 2023. I have no idea how many we're going to see passed this year, though I wouldn't be surprised if it was another half dozen, give or take. I could just as easily see it becoming 12 or even 15 that kind of get it together this year. We'll just have to see. Question, yes. Frank, you're up.
I guess, is there a reason why we can't have like a national one versus each state? I know looking at this, it seems like every state is sort of, at least in terms of the rights of the data subject and the obligations, seems to be pretty fairly consistent across all of them. So why, what would be the hurdle?
Politics. It's politics. There actually was and remains technically a American Data Privacy and Protection Act that's in Congress, in the right committees. It's just stalled. Washington D.C. is dysfunctional right now. Simple as that. And in any like sane time period, yes, Congress would act. They would pass a federal law, and it would stop being this confusing. We'll see how bad they let it get. At a certain point, industry is going to be like, okay, we've had enough. Pass a law, something, do something, because nobody wants to deal, even though they look very similar, and they are, there's still some differences between each state. A good one is actually kind of interesting. You would think that California sets the bar for all cases, but California does not necessarily set the bar for all situations. Colorado and Virginia have rights to appeal a negative decision. California didn't think of that. Maybe they will. I'll probably just put it in. But you know, that's the kind of issue that companies face dealing with this is, you know, I can walk 50 feet across a state border and suddenly my privacy rights are different. That's hard enough without the internet. With the internet, it's almost impossible to deal with. So it is worth, this is the only slide that really goes back to 2022, and I only mention it because it's when the California Attorney General settled it's kind of one one really only CCPA case that it brought against Sephora. It was only a $1.2 million settlement, which is, it's not much, but the requirements and the injunctive relief were more extensive, and it was such a minor technicality that got them in trouble. Basically, they weren't honoring a universal opt-out mechanism called the general privacy control, and it's questionable in some ways whether they even had to, but they settled anyway because 1.2 million is less than they would have spent fighting the AG's office. So that was really the only highlight I wanted to share there. I'm going to go a little faster. So 2023, what happened throughout 2023? So we had this the framework for transatlantic data flows that ultimately became the data transfer framework, or no, DPF, data privacy framework. It's being just as challenged as all of the previous versions were. It's supposed to be the new privacy shield. We'll see what happens. Not only Mr. Max Schrems has challenged it, but also a member of the EU Parliament has challenged it. So if I've learned anything from how the court system in the EU works, it will be another couple of years before we know what to make of the data privacy framework. I put it down here because I think it has had impact. The White House National Cybersecurity Strategy was published March 2nd, 2023. Not a law, but it's had a lot of effects on federal agencies. NIST has done quite a bit with it. The SEC has been responsive to it, as we'll see. DOD, basically every federal executive agency has had to deal with this cybersecurity strategy. And I think largely it's been a good thing. It's at least drawing attention to what we all know to be significant problems. Okay, this is a whole slide just for the Federal Trade Commission. So I put that top bullet up just because it was late. It was actually in 2021, they finalized, or was it even 2019? Now I can't remember. But basically the updated safeguards rule for financial institutions that the FTC gets to promulgate and put out there was supposed to go live in December of 2022. It did not, but it has since gone into force. It was in June of this year. The interesting thing about the FTC and the Gramm-Leach-Bliley Act is I still can't figure out exactly all of the federal regulators under this act. It's supposed to regulate the banking and financial industry. And does anyone know how many banking regulators we have in this country? Like, I've counted at least 6. And the FTC isn't one of them when it comes to actual, like, anything that you would think of as a bank. However, it turns out that the term financial institutions can be incredibly broad. And my favorite example is this company called Lightyear Technologies, which I may have mentioned in this room before, which they're a company that makes software for car dealerships. And like when you go back into the back room to see the financing and insurance guy, you might get a credit check. Well, that was enough. That the fact that the software was involved in a credit check allowed the FTC to say that it was a financial institution for purposes of the GLBA safeguards rule. So they got in trouble for failing to comply with the safeguards rule. What this tells me is, and what I advise clients is that just because you don't identify as a financial institution doesn't mean you aren't one, at least for this definition. So if you're even close to it, I would, ask your in-house counsel or outside lawyers, hey, do we have to comply with the FTC's GLBA safeguards rule? Surprising number of clients do actually have to comply with it. So next up was this Epic Games order. This was kind of entertaining, at least from the outside. COPPA is the Children's Online Privacy Protection Act. Section 5 is the general unfair, deceptive acts or practices. And what the basically what the FTC said was Epic Games, by the way, anyone doesn't know Epic Games, they're Fortnite, basically. They were violating COPPA basically by not getting appropriate parental consent for children under the age of 13 to play Fortnite and collect their data. If you've played it, you probably know that it kind of makes sense. And then there were these, technically it was a separate action, but there were all these dark patterns, which is a phrase that basically means weaponized psychology used to trick people, is how I think about it. It can be subtle. It's almost always subtle, otherwise it doesn't work so well. But it's like doing things like you can sign up for something online in one click, but canceling it takes you 5 hours on hold on the phone. That would be an example of it. Another classic example is adding something to your cart during checkout that you didn't actually put in there. Maybe it has a pre-checked box. Aaron knows I loathe pre-checked boxes. Checkboxes on to indicate consent. So those are the types of things that Epic got dinged for. And this was $500 million. That's a lot of money. Fortunately, Epic sells a whole lot of cosmetics on Fortnite, but the FTC was not messing around with this one. I don't know if it's mentioned directly, but Microsoft also paid I think it was only a $20 million fine for COPPA related to, I want to say it was Xbox, but I might be wrong about that. You've also got a couple of companies that got hit with the FTC's health breach notification rule. This one's really interesting. I would love to spend time telling you about it, but the short version is there wasn't an actual data breach the way that any security practitioner would ever think of that phrase. What it was these two companies sharing data with advertisers and social media companies while saying that they weren't going to share your personal information with these companies. And it was really more of a self-own in a way, as opposed to an actual breach. Nonetheless, this year's FTC decided to go for it, and they were able to get both of these companies to settle. And then last but not least, I thought this was kind of interesting, very unusual, but you had the FTC chair and officials from the Department of Justice, the Consumer Financial Protection Bureau, and the Equal Employment Opportunity Commission release this joint statement on AI that basically just said, there's no exemption for artificial intelligence in the law, and we're watching you. It's weird. I've never seen anything quite like it. Then again, I don't think the world has seen anything quite like generative AI and the speed with which it is moving. The point was really for these agencies to say, there's no, like, we don't care that you're doing it for AI. Like, it doesn't matter. If what you're doing would be illegal under any of our laws, it's illegal whether it's done with AI or not. So a good message, just oddly phrased. And I think they did it because they frankly don't know what's going on any more than anyone else does. Something you don't see very often, but I think it's worth, yes.
Did you see that?
I did. I saw the
Yeah.
headline.
Yeah, I read the article actually. I mean, it's very interesting with what you just showed about we're watching you, right?
Yeah.
I mean, I think it does set people up to know that they might be successful in those suits. I don't know if you know more about it, but
So I will say this, copyright in AI is a totally different presentation. It's fascinating. I have no idea if any of these suits are going to be successful. If I was going to bet on it, I would bet against them. I think they will not win. but we will know in the next couple of years, realistically, on this, what that's going to mean, and it's going to have a lot of wide-ranging effects. But you're right, that did just recently happen. Major authors have sued. Basically, anyone whose works were used as training data is trying this out to see what's going to happen. Much closer to us as security professionals is the SEC's rules. These were finalized in July. They became effective a couple weeks ago. And there's a couple of kind of, I think, interesting components to the new SEC rules. They are reporting rules, disclosure rules. They apply to public companies, not they don't apply to any privately owned company. And essentially, what you have to do is every year, whenever you would normally file your 10K annual report, you have to include a pretty substantial section on cybersecurity. And what you have to do is explain. And by the way, we have no idea like exactly how people are going to do this. I think over the next few weeks, you'll start seeing the first 10Ks filed. Maybe a couple already have been filed. But what you have to explain is essentially, what are you doing for cybersecurity risk management? What kind of expertise do you have on your board? Does the board oversee the business with respect to risk management and cybersecurity? Pretty fascinating. And then 20F is just the same thing if you're a foreign corporation. And then I think what really made the news, at least around the cybersecurity industry, was the 4-day disclosure of a breach. And turns out that's not quite accurate. It's 4 days from the determination of materiality of a breach or an incident. That's quite different. You may not know for a week or more if something is going to be material. Then again, you may know right away, in which case you won't be able to get away with unreasonable delay while you figure it out. But that's so incredibly specific and dependent upon basically every set of facts. And otherwise, it's a pretty typical, disclosure, data breach notification type thing. Well, actually, it's not a data breach notification. It's an incident. It's a material cybersecurity incident reporting requirement, which is quite different if you think about it. There doesn't have to be a data breach at all for it to be necessary for you to have to disclose under this new rule. So it's going to be, I think this year is going to be fascinating to see how many get filed, what they say, how specific are they. I mean, all of us at this point have gotten, boilerplate data breach notification letters that say basically nothing. My prediction is that you'll see some companies that manage to say even less than those notification letters.
Oh, just a question from the audience, if you want to finish your thought.
Yeah.
So Mitch online asked, aren't attackers now turning their victims into the SEC for late or no reporting?
Yeah, I did see that. Unfortunately, that first one did it before the rules went live, which was, I suppose, good attempt, but a little too early. That's going to just be another coercion tactic. I don't think it's going to have a material long-term effect. Companies are going to quickly realize that if they've experienced an attack that is severe enough that the attacker is thinking about trying to report them to the SEC, it's probably material. In which case they'll have to go ahead and disclose it anyway. So
this is going to fall into more like the ransomware scenario,
yeah,
where people are going to expose companies, ransom them, and then expose them.
Could be, which, I mean, if you actually were afflicted by a ransomware attack, that would be generally considered material. So you'd have to disclose anyway. So you could probably just ignore them if they say, and we're going to tell the SEC that you've been hacked. It's like, yeah, well, so were we. But we'll see. We just don't know. 2023 is going to be, or 2024 is going to be interesting on that point. Not to be outdone, the FCC, just to be clear, the Federal Communications Commission, also updated its data breach notification rules. This really refers to, I mean, the 3 major carriers for cell phones, and then all the other regional, you know, plain old telephone system companies that are out there. Basically, the rules were kind of old. In fact, they were very old under the FCC, so they've been updated, and now they operate more or less like you would expect a modern data breach notification rule to operate. So I don't think it's a major deal. I frankly hadn't even heard about it until I was busy updating this, and then I was like, oh, look at that, another one. What do we have coming forward though in 2024? So I just read speaking of articles that randomly pop up, I'm skipping down a bullet point. But apparently Google really is going to eliminate third-party cookies on Chrome this year. The article I said, of course, the article I saw was, of course, kind of lamenting the fact that this is still way too fast and the advertising industry isn't ready. I don't know if that's true or not as a matter of fact, but that is going to be a big change. The loss or the kind of lack of third-party cookies will fundamentally shift privacy discussions and could really change what future laws require. Some of the California laws regulations will stop making sense if there's no third-party cookies. So it'll be interesting. I mean, what's so much fun about this practice area is that you never know what tomorrow is going to bring. Not only are the facts changing underneath you, but the legal landscape is, of course, evolving on a regular basis as well. To go back to that, the top bullet point, the use of universal opt-out mechanisms. As I was mentioning, this is kind of the general privacy control. The GPC is not the only one, but what you see is an increasing number of state regulations requiring some manner of this low friction opt-out. And what the California Privacy Protection Agency did, which will take effect in March, is I think they kind of went beyond the CCPA and are requiring this opt-out even if you have a do not, I'm gonna grab that door. You got it. Even if you have a do not sell my personal information link. So I wouldn't be surprised if there were challenges to that. It's pretty interesting. What it means is that every website, every company that operates a website that uses third-party cookies or really any manner of quote tracking is going to have to re-engineer their website to honor these signals that are going to come from browsers.
Like, so Google is not the only browser company, right? Like, for example, Safari and Firefox, I believe they've already stopped using third-party cookies.
So I'm not an expert in this area. I think Safari has cut back. I know Mozilla, Firefox, and Safari kind of cut back on tracking cookies several years ago. But because of Chrome's market share, it's had a limited impact on the advertising industry. And I think that once Chrome stops using them, that will really signal an actual change in practices.
Another question online here. Just gotta read it because yeah, it's long. Given the increased cause to send CISOs to jail, won't these rules that punish victims have a deterrent effect on security professionals through worsening the problem?
So I have a slide that addresses that. So I will ask that person to wait a little bit.
So Mitch, you just gotta wait.
I just gotta wait. Yeah. Okay, so it's gonna go through here a bit more. Canada did something. The UK they introduced a draft data protection reform of the GDPR law there. Don't believe anything came of it. I don't believe Canada actually passed C27. France did actually fine Clearview AI 5.2 million euros. Maybe it was 20 million. Maybe there were two different ones. But frankly, not that interesting compared to the other things that have been going on. So at the US level, you had asked about why isn't Congress doing anything? There's kind of two separate tactics being taken. One group is pushing for privacy laws that focus on protecting children because I guess who doesn't want to protect kids? That should be easy in theory, right? Everyone should want to protect children from, having their privacy stolen online. To that end, a couple of senators have been kind of pushing COPPA 2.0. The other side of that is the American Data Privacy and Protection Act, which would have covered the entire economy. I don't know, other than political dysfunction, why these things aren't moving forward. I think they will someday, but I'm not holding my breath at this point. So then I had to have one slide on the CMMC, which is the Cybersecurity Maturity Model Certification Program for the DoD. So if you're a defense industrial base, if you're a member of the defense industrial base, then you do need to move down the CMMC pathway and become certified. And it has taken years. They have just recently released a 300-page draft rule. No, I have not read it yet. It did come out, I think, last week. People will have the right to make public comments on that for a few months. And I think maybe 2024, this will actually all get finished and take effect. What it will mean is, again, if you're a defense industrial base company, which actually could be pretty broad, most tech companies have at least some aspect of that. If you're a supplier to a supplier to a supplier of a defense industrial base, it could still apply. So you have to kind of understand your industry. And essentially you take what will be the third iteration of NIST Special Publication 800-171, and you have to do it. That's kind of the super quick and dirty mechanism, is you need to deal with it. Specifically, this has been about something called CUI, which is confidential unclassified information. So it's not secret, top secret, etc. data. It's not something you need a security clearance for. That's what the unclassified aspect is. But it is confidential. So this is actually a huge amount of data, probably almost the vast majority of data generated by defense industrial based companies would fall under this. So it's a big deal. I've got a whole podcast episode on it where I interview Jacob Horn, who's kind of famous on LinkedIn for talking about this. He's a good follow. He's a CISSP. If you haven't followed him on LinkedIn, I highly recommend doing so to learn more about that. Okay, now we're to the states. So I put in one bullet point. I want to point out that California is not the only state who's been taking their privacy law and adding another 50 or more pages to it using regulations. Colorado also did this. Finalized in March 2023, they literally did add another 50 pages of regulations about privacy in Colorado. So I'm not going to talk much more about that, but it's something to be aware of, that you have the law, but then you also have all the regulations that get passed. And it's interesting to see, like Virginia hasn't done this. Most of the other states have decided not to tack on regulations. I mean, California didn't until, no, I guess California always did. They were just slow about it. What else we got? So I think I mentioned this. Delaware, Iowa, Indiana, Montana, Oregon, Tennessee, and Texas did all pass. Not all. The reason they weren't on the previous slide is some of them don't take effect until 2026. So you got some time on those. And I remember doing this. I'm curious to see how close I am. I bet it's more than just these four: New Jersey, North Carolina, Massachusetts, and Pennsylvania that passed this year. I should have put Washington up there, but I'm kind of sick of doing that because this will be the 6th year that Washington has been really close, honest. We'll see, but this is fun. What did get passed last year in April and will take effect pretty soon, March 31st, 2024, you know, 3 months away, is the My Health, My Data Act. This is what I'm lovingly calling a HIPAA gap filler. And so that requires a bit of explanation. Most people incorrectly think that HIPAA covers anything that even touches upon medical information, but it does not. It only covers protected health information, and protected health information can only be created and moved around if by a covered entity and its business associates. What that means is that, particularly in the modern day with these watches, all kinds of stuff, there's a ton of health adjacent data that isn't technically PHI because Apple is not a covered entity, nor is Fitbit or any of the or Peloton or any of these companies that have your health related data, but are not otherwise regulated by HIPAA. So My Health, My Data comes in and says, okay, whatever consumer health information exists that's out there that is not covered by HIPAA is now covered by this law. And this law is the exception to that no private right of action that I was mentioning. I can't honestly overstate how big of an impact this law could have more than any of the other ones. I'll get to you in 1 second. Because of the private right of action, there will be class action lawsuits, probably quite a few, starting April 1st. And the problem is that the requirements of My Health, My Data are pretty extensive. It won't be that straightforward to immediately comply with it, assuming companies even know about it. And the level of operational headache that's going to arise from it is going to be pretty interesting. I say that from the perspective of I'm going to be the one who has to help the clients figure out how to comply with it. And it will be a headache. I don't think it's a bad law. It just will be difficult to do. So go ahead, a question.
Do you have an opinion as to how like Google or Microsoft or other search engine vendors are going to be impacted by this as it comes down to people just putting health questions into search engines? Because technically that's health information.
So that's a good question. I don't know if that's going to end up being impacted or not. The issue is, are they logged in? Are they not logged in? I mean, I can tell you that, like, take Bing as a good example. I'm not picking on Bing. It's just that I tend to be logged in for whatever reason. If I type in, you know, how do I treat this growth? You know, yes, that's medical information. It is. And they know that it's me asking it. Now, of course, they could say, well, we don't know it's about you. I mean, maybe you're just randomly trying to search about the growth. Who knows? But it is a, maybe these companies will have to be like, it appears that you're making a search involving potentially, you know, health related information. Please click this button to confirm that you want to do this, and they'll get consent that way. It's going to be interesting.
Is kind of along those lines, but will this also include things like schools that request students' health information?
I would have to check if it impacts government agencies. Yeah. So a lot of the requirements are about consent. and I think that schools at least already get a ton of consent from parents anyway. So I imagine that they'll, if it does apply to them, and I don't know that it does, I imagine that they could handle that fairly easily. But the really interesting thing about this is that it actually does give you the right to vindicate your own rights, unlike the rest of these state privacy laws. So that'll be a big difference. California will continue to make rules. Oh my goodness, they are making so many rules. I have a whole slide on that coming up shortly. Something that's not terribly uncommon in the Attorney General circle is this idea of an investigative sweep. I was involved in several of them during my 8 years there. Basically, someone decides that we're going to pick on industry X, and they just start a whole bunch of investigations in industry X to find malfeasance, and inevitably then they all gang up on whoever's the worst. Happens all the time. Usually it's probably in the public's best interest. Like, don't get me wrong. But that's all that. What that means is that as these laws proliferate, if you draw the attention of one AG, let's just say that it's just a matter of time before one assistant attorney general brings up their case on a conference call with the National Association of Attorneys General, leading to 5, 6, 7, 8, 10, 50 other states piling on. So what could have been a one state investigation becomes a national investigation. And then sometimes the FTC will join in. Sometimes the FTC starts it. I've been on calls like that more times than I can count. It happens. So that's why these things matter in this context as these laws proliferate. This is Colorado. Wanted to point out that I don't know why this was done exactly, but on July 12th, the Colorado AG sent a bunch of letters out saying, we're going to start enforcement of the Colorado Privacy Act. I think, to me, that like, you don't do that unless you're actually going to enforce it. So my expectation is that the Colorado AG's office is going to be busy this year, but we'll see. So these are just, again, show you the dates. Texas is July 1st. And this is kind of the initial date for some of these laws. Texas kind of phases in over time. Some do, some don't. But that is kind of what I wanted to show you there. Here's a quick scope comparison. So this is interesting. California is the only one that has this 25 million annual gross revenue or threshold. So what this slide is trying to show is how big of a company do you have to be before these state privacy laws impact you? Like, if I put on my privacy advocate hat, I say that this slide is garbage because a whole lot of personal data gets collected by small companies. So if you actually care about protecting personal information and data, it would apply like the GDPR does to everything, even nonprofits. Most of these laws never apply to nonprofits, no matter how big they are, which is, if you've worked in the nonprofit or know of any nonprofits, you might think to yourself, that doesn't make sense if we care about privacy. And that's the problem with a lot of these state laws, is that they talk a big game, but don't necessarily follow through on it. And if you read this, like, I think Montana at least had the presence of mind to think, our population isn't necessarily that big, so it's only 50,000 consumers. Connecticut, though, didn't bother with that. A company has to process the personal information of 100,000. Oh, why did I pick that? Connecticut, whatever people are who are from Connecticut, whatever they call themselves. What is it? Connecticutans? I don't know. But that's actually a fair number of people. Delaware was the best. They at least realized we don't have a big population. So if we picked 100,000, that's like what? 1/6 of like 1 in every 6 people in Delaware. So they went with 35,000. Bottom line is that for the most part, it's a numbers game. What I tell clients is, if you're close, start complying. If you're nowhere close, you don't have to worry about it for at least some time. The exception here is Texas, which is actually pretty interesting. Is a very squishy definition. If you go and look at the Small Business Administration's definition of small business. So in some ways, Texas has the best law when you think about scope. Utah has the worst in some ways. I think what's missing from this chart, because there was only so much room, was Utah is 25 million and process the personal information of 100,000 or more consumers. So,
Jake,
yes.
so you still have to have a breach to initiate this process, right?
No, no.
Or
No. There's no. So when I say a law applies to you, that means that you now have to give people all of those rights, which operationally means you have to be able to accept data subject access requests or consumer privacy right requests, things like deletion, access. My favorite is data portability. Can you export, if I ask you right now, can you export my data in a human and machine readable format, like XML or JSON or anything else, maybe even, or CSV even? If the answer is no, well, you would be in violation of any of the state laws that require you to have the right to data portability. So this has nothing to do with breaches for the most part. It's about these new rights that you can exercise, and then a number of obligations around data processing and transparency. I mean, I can close your eyes.
The second question I had to that is, what's a reasonable request at this point? Can any consumer, it's like, can you end up in a situation where you're fundamentally being overloaded by
Yes.
unreasonable requests as a result?
Potentially, yes. And so I've been working with clients on this issue for several years now, and so far, most clients have not needed to create an automated system that allows for high volume. On the other hand, there's one client who I probably spend a couple hours a week talking about random data requests from all over. Because do you think people understand that they have to be from a certain state? My favorite example is the person who used their normal address in like Ohio or some state that did not have a privacy law, but changed the state only to California because the system wouldn't let them complain unless they were from California. So they ended up using a city name and a street address in Ohio, but just said they were from California. So the complaint did go through. What do you do with that? You have to have a response. And I mean, yeah, it can be a pain, no question. Sorry, let me go back to where I was.
Well, so while you do that, could that now lead for, again, that example that you gave, that's a great opportunity to now to do some discovery for bad actors, right?
Yes, and the only saving grace, if you think it's that, is that most of those state laws can only be enforced by the AG's office. So, like, it's at least it's a government action that has to get taken. It can't just be, Joe Ambulance Chaser deciding to start enforcing privacy laws, which will happen in Washington State with My Health, My Data. Just, I'm calling it now. Anyway, here's a map updated toward the end of the month, last month. All the bright green states have already signed a law. Those are the ones we've been talking about. All of the ones in dark gray, those have those have bills that are merely inactive. So Washington, Minnesota, Oklahoma, Louisiana, Mississippi, Illinois, New York, all of those, and all the other ones I can't see, those all have bills that may have gone almost all the way. So any of those are liable to pop back up and get passed. All of the states in light blue or teal, turquoise, I guess, they've at least had something introduced, if not make it to committee. And it's only that light gray where they've had nothing introduced. I kind of disagree with the IAPP. Florida did introduce stuff. Not quite sure why they're listed as having not done anything. But it's most of the country and certainly most of the population that will soon be impacted by a comprehensive privacy law. Of course, you do also have the global privacy law, comparisons. I'm not going to spend time on this because we don't have time. I can have some time. That's good. So enforcement. I just figured out this was converted to Google Drive and then back into PowerPoint, which is why if there's things missing and messed up, like those boxes should have been an arrow. So this is old news except for the bottom one. So what happened was the California Chamber of Commerce sued the California Privacy Protection Agency in, I want to say, the summer. This was because the enforcement of all of these new regulations that I barely had time to touch on was supposed to start July 1st, 2023, but they were slow. The CPPA didn't actually get its final regulations published until March 29th, 2023. And so the argument was, no, the statute requires that people get a year before you can enforce these new regulations. So that's why you see now that the regulations will become effective on March 29th, 2024, which is not that far away now. I don't know if the CPPA was trying to fight it. I think they were, but at this point, it almost doesn't matter because that's not that far away. So that's important. Ignoring the top part, because I kind of already talked about it a little bit. The one thing is to point out is that the CPPA is a growing agency. It's a baby agency right now. They barely have any staff, but they're constantly adding staff. So they've been very busy and focused on making rules. And why? Well, because once they make the rules, then they get to enforce those rules. And I don't know their funding structure exactly. My guess is they're going to get to keep some of what they kill, which will mean they look a little bit more like a private plaintiff's firm than a government enforcement agency. This would not be unique amongst state AGs. The state of Oregon's Consumer Protection Division in its Department of Justice has been self-funded for 20 years. Our own, do we have to stop soon? Right, okay, I'll wrap up. This one's important. The California Privacy Protection Agency, like I said, they've been writing new rules. So they didn't stop with the rules I mentioned that are only going to come into effect. They've kept going. And this is great, you guys. I kid you not, on December 8th, just last month, less than a month ago, they unveiled new rules and regulations covering cybersecurity audits, risk assessments, and what is going to become, I'm sure, a four-letter acronym, the use of automated decision-making technologies. They're pretty extensive, a couple dozen pages per rule. Maybe that's not quite, that's probably about right, 20 pages, give or take. Check them out if you think California is part of, if you're doing business in California, you otherwise meet the threshold of applicability for CCPA, you'll have to start worrying about this as well. Some more detail here. These audits, and by the way, the CCPA itself, the actual statute doesn't really talk about this. This is essentially made up as a rule, which they can do unless a court tells them otherwise. This is where you have to assess and document your cybersecurity program to make sure that it is consistent with the risks that the data you're collecting faces. I don't know if it's going to get into the level of detail of CMMC, which requires a qualified third-party assessment organization, lovingly called, I think, the numeral 3POA or 3PAO, something like that, 3PAO. You've got the ADMTs, which this is going to become really common. Your company uses an automated system to scan incoming resumes. congratulations, you're using an ADMT that is probably going to be subject to these rules. There's so many examples out there. I don't have time to go through them all. The risk assessment, probably you should be doing them anyway. I'm a big fan of risk assessments. You'll have to if the CCPA applies. Kind of already covered that. Here's the slide I always use. We're up to 4.4 billion euros total fines over 1,953 enforcement actions under GDPR. The data is through December. I don't know how much more detailed they get. Still, 2021 was the biggest year in terms of actual numbers. You'll note what's kind of interesting is that if you subtract these top 5 fines from the 4.4 billion total, you will see that there is not like those top 5 account for, what is it, roughly half, maybe even a little bit more of all fines issued under GDPR. The reason I have this slide is that some people think it's been a paper tiger. I don't know. It depends on what you think 4.4 billion euros is a lot of money or not. Oh, unfortunately, I'm not sure I'm going to have time to talk about SolarWinds and Timothy Brown. Here's my quick and dirty version of it. This is not a lawsuit over a failed cybersecurity program. It's a lawsuit about lies or misrepresentations that were made about the company's cybersecurity program. I have no facts other than what you can find in the public complaint. What I can tell you if you're a CISO or thinking about becoming a CISO is that don't lie. Not on purpose, at least. Keep a record, CYA emails, make it very clear that if the company overrules you, that you can prove with an email trail that you didn't approve it. It just isn't about that freak out of that. There was this initial freak out that, oh my gosh, we're going to go to jail if we don't have good cybersecurity. Well, first of all, this is a civil lawsuit. You can't go to jail. He can be fined. He might pay some money, but he can't go to jail. I think you just have to be very careful about what you say. Skip this slide, skip that one. I'm going to skip a bunch of these. This one's interesting. I can talk about it some other time. If you come to have drinks with us afterward, I'll tell you about it. Rite Aid just got in big trouble. This was like 2 weeks ago because they were using facial recognition technology in their stores, and it was basically not working. It would racially profile. It was just not functioning well. Here's the slide I wanted to get to. This is great. Okay, you ready for this? So this is a slide of all the FTC enforcement actions that I found going over their website before this presentation. I count 13 actual actions, and then I'd stopped, but there were 37 press releases related to privacy and security. So this FTC, I have been in this space working with the attorney generals since 2007. I have never seen an FTC this active, which, if you know the commissioner, shouldn't surprise you, but that's what it is. And this one is the only other one I wanted to mention before I stop and we clean up. If you haven't heard about this basically pixel tracking issue, really fascinating. Essentially, certain hospitals, it actually goes to your question about medical information, except this time it's talking about actual covered entities doing HIPAA violations because they're using usually the metapixel, it's just Facebook's tracking pixel thing technology, and they found, there was evidence found that in some cases these pixels were straight up sending patient information to Meta, and I have to say, I don't usually do this. It wasn't Meta's fault. Like, it wasn't. This was not a Meta issue. This was a hospital or healthcare provider outsourcing their website development and advertising and marketing and not understanding what was going on. So rarely will I, this was just not Meta's fault. I leave you with this. I think the future is more privacy laws, more federal enforcement, new enforcers that don't even exist yet. I think the CPPA is not going to be unique. And AI regulation is you can bank on that. As for CISO liability, it has the question mark because I really don't see that happening any more than any other officer has liability. I think CISOs should just be more careful about making sure they're part of the officer liability insurance, things like that. I think you can actually mostly relax about that. So there you go. That was
Awesome. Could you jump over back to the other deck? Thank you very much, Jake.
Yeah. Very nice. Yeah.
Might have to screen share again.
Yeah. This is very slow PowerPoint. Oh,
I think that's it.
that's it.
All right.
I don't
actually,
need
it's
to
not.
I don't need to screen share.
No, you don't need screen share. All right. For everybody online, thank you very much for joining us. For everybody in the room, like what we do always is we meet up at the Roanoke. It's not that nice and sunny in this picture. It's obviously a lot more gray, and that parking lot is full. So keep that bear that in mind. There is parking. You just got to hunt for it. You're welcome to join us. Tonight, everybody is paying their own way. So again, great opportunity to talk to Jake. Maybe even, I'm gonna go. Yeah, Jake will be there. So February, I will hopefully see all of you. We will have elections, and I look forward to making sure that we have a great year that's coming up. Micah, thank you very much for all the AV today, and see everybody next month. Bye. Oh yeah. 4 people in the room. All right, we'll discontinue the online meeting now. Thanks.